Then motor is admitted in hospital and filed the IA for entry.
The pension matter में the old man of 80 years, he was retired from service on 2001 millet. So since that date, he is not getting his pension.
May I please receive my lord under section 30234 IPC my lord 10 years custody my lord.
Matter relates to compensation under Land Acquisition Act and
Please give.
the appellant is in jail custody more than 12 years.
12 years. Please give.
Opposite party will initially deducting salary and the third of the petitioner is law sergeant without getting.
Yes. My lord, one jail appeal appellant in custody more than 7 years. Another also my son.
Supplementary list. Item number 1.
Directed us to take instruction with regard to the letter of district judge insofar as the payment of consolidated remuneration is concerned.
Refixation of his salary and
Yes.
pursuant, but
Yes, we have received the letter and from
that
the
is
Home
true. But very
Department.
disturbing that despite the letter being issued by the High Court, since long the
Yes.
government is
Yes, sir.
sitting over the matter.
Yes.
Kindly pursue. Unless the government clarifies this, how can we
Government
pursue
has
it?
clarified by Home Department by a letter.
Already clarified.
Yes.
Where is that?
But, we have received the letter.
You have
May I
received it?
read that? The consolidated remuneration of Sri Prabhakar Tulo, retired bench clerk engaged as bench clerk grade 1 in the Court of Ad hoc Additional District and Session Judge FTSC Bhawanipatna has been correctly fixed at 20,000 rupees per month as per para 2 of FDOM number 2453 so and so dated 29/9/2022. As such, there should not be any refixation of consolidated remuneration allowed to him.
Because this is not the correct clarification. This is the notification wherever the retired employees of grade 1 have been posted in the ad hoc post. That is a consolidated salary that their remuneration that they are getting is 20,000. Here is not the case. Here is a case whether he is entitled to the RACP or what is that of 2017 rule or not.
I got that, but this has come. So I pray if your lordship kindly permits me, I'll file a counter explaining this also. And once I have taken note of the averment, which has also not.
Land and Council for the state submits that though he has received, but we have received.
It's instruction and letter of Home Department.
He has received instruction from the Home Department, written instruction from the Home Department.
And parawise comment from the London District and Session Judge.
Parawise comments from the London
District and Session Judge, Kalahandi Bond.
District and Session Judge, Kalahandi Bhawanipatna. He wants to file counter-affidavit and sometime in this matter after 2 weeks and counter-affidavit copies are on the Land Council for the petitioner.
Yes.
Okay.
After 2 weeks.
This in order number so it should be read as one here.
Okay.
Item 2.
Some 2 minutes, the lordship directed to take instruction and my submit.
No, he was directed, the petitioner was directed to comply certain.
If your lordship, and from the petitioner, we already took time 2 times for filing the certified copy of order passed by the ASO, but it has not received. So, lordship, I pray for withdrawal the case.
Withdraw. File and
Later application. Liberty to handle it.
You have power in this case.
Yes.
What is your name?
Yes, Mr.
S. Misra, Land Counsel for the petitioner, files a memo for withdrawal of the writ petition, seeking liberty to file a fresh writ petition with better particulars. Memo is taken on record, writ petition is disposed. Yes.
Item 3.
Not file the counter the second time, twice. This is regarding dismissal of case on limitation without touching the merits.
The Office of Deputy Solicitor General.
Video on करो, video on करो. Item number 3. DK sound or Dilip sound.
You took time to file counter affidavit. So what is your instruction? Where is Mr. Padi?
Your lordship press for adjournment, your lordship. But
No,
another
the
count.
matter was taken off.
Second time.
First on 21/10/2024, and thereafter on 12/11/2024, Mr. Pari submitted before us that he has received the Parawise comments, and within 2 weeks the counter affidavit would be filed. That was the submission or the statement made on 12/11/2024. So not only 2 weeks, but 8 weeks have already expired. So you are not filing the counter affidavit. Yes, madam.
Your lordship pass over other or adjourn this. I have no knowledge about this.
No, Mr. Pari is supposed to address us after if we pass over this matter,
Your lordship
or
pass.
he has some difficulty or what. Please say something.
Your lordship adjourn this matter, your lordship next week and other day, your lordship.
No, why you took time for, if you have received the Parawise comments for filing the counter affidavit on November 2024. We are in January, and why are you not filing the counter affidavit?
Your lordship in this case conducting another CGC, your lordship. He is also absent, your lordship. I have
Then
no
we are,
knowledge.
if you say we can pass over for some
Your
time.
lordship pass over, your lordship.
Okay.
Item 4.
ଶୁଣିଲେ ନାହାନ୍ତି କଣ ଅନ୍ୟ କୋର୍ଟରେ ଅଛନ୍ତି ବୋଲି କଣ କହୁଛନ୍ତି ଅନ୍ୟ କୋର୍ଟରେ ବୋଧେ ଆର୍ଗୁମେଣ୍ଟ କରୁଛନ୍ତି
Next week.
Next week. All right.
Item 5.
Order under Annexure 6 at page 173, passed by the Learned Administrative Tribunal, rejecting the review on the limitation as if the merit is under challenge.
Oh, have you served a copy of this writ petition on the,
No, no.
and who is supposed to appear for the, there is a private party is there?
Non of private appeal. The AIMS is the petitioner.
Okay, MC is the petition.
Non-appears is written in the review petition. That's it.
No, what is your prayer in this writ petition?
The petition to watch the review order as well as the both.
Annexure 6.
Annexure 6 176 the review. Grounds taken in review for the appointment 2000.
Who has filed the review petition?
The AIMS,
Okay.
the petition.
Okay. No, the original application was filed by whom?
Opposite party applicant.
Daitari Swine.
Daitari Swine.
Yes. For what purpose he filed the original application?
Your prayer may conduct glance of lordship for citation case 31.
31.
31. Relief shortfall.
Just a moment. Yeah.
The respondent will direct to sanction, give the payment forth to the applicant, thereby promoting her to the post of associate professor in nursing in term of advertisement dated 2012-2011 under Annexure A1, as the applicant in the meantime has already completed 4 years 10 months as an assistant professor. 2. The select list 26-12-17 under Annexure 4 with regard to the post of associate shall be quashed. The action of the respondent in not sanctioning giving payment for to the applicant, thereby promoting post of associate professor shall be declared as illegal. So is the main claim before the for promotion to the post of associate professor of sanctioning of the payment for on completion. Here is the he was 2012-2011. 2011 Annexure 1 page.
No, what order was passed by the tribunal?
Lordship may can say that order is at have been closed at page 81, starts at page 81.
That is Annexure 3.
Annexure 3.
Page 81.
81. In a peculiar circumstance disposed of.
No. What ultimately what is the finding? The
Finding at page 86.
86. Yes, please come to that.
Para 6.
Yeah.
In view of the fact the circumstance discussed made above, and since there is no averment or documents produced by both the parties, whether the representation dated 2/1/18 Annexure A by 8 applicant has been disposed of or not, the O is disposed of with a direction to respondent to consider the same in the light of judgment Tribunal OA 236/16, which has attained finality and passed a sweeping order to communicate the applicant within a period of 90 days.
Yes.
So far the Annexure A by 18 as ever, neither it was in the OA.
No. Thereafter what happened after the direction?
That has been disposed of.
Then you filed the review petition.
The review petition filed because here is the point of question is here to consider. 2011 she was appointed. At the time of 2011, at the AIMS was in a nascent stage. There is no amended, there is no approved.
No, somebody has filed a representation. The tribunal has said that you dispose of and you keep the light of the in light the judgment of this court. So if you say that the judgment is not applicable, that man.
Yes, that's right. On that ground, review.
Why are you not communicating the order to him? Why you file the representation?
Already communicating there.
Then why you file the representation and approach this court again? That means in this writ petition. Why you sought for review of this order?
Review also ground of review. Lordship may conduct page 9.
When the direction was issued just to dispose of a representation, why you file a review petition in that?
The two things was not considered. The judgment order relied on to file question way is not applicable. And in 2013, the advertise.
See, कहले तार आपण consider करिवे सेटा आपण लिखिन जणे इथादे जो judgment अछि इटा applicable नुहे ताकू गोटे review file करी पुनी ता against high court पसी कि कोन गोटे कोन देले गोटे representation dispose of करिया देले. If the man is not entitled to get any relief according to you for this reason, you are just to dispose of the representation and communicate the order. Matter ends there.
It is representation of disposed.
What is that?
At page 183.
183. Then if it is
Annexure?
disposed of, then why this
They are
review petition? Why this?
Because the contempt was subsequent filed. There's no new.
No, no, if contempt has been filed, just when the order was passed in that way.
OA order on 2/4/2024.
24. Thereafter, if you have disposed of that representation and you have complied the order, if contempt application of has been filed, you can produce that order that
Yes,
you have.
we have produced before.
High Court कौन पे action no?
They only that review that the rules is in 2013. The rules
No. That order is complied.
Complied.
Once you disposed of the representation of the candidate, so the order has been complied. So that you would have mentioned.
Now he is to challenge this.
Yes.
Because the representation you have disposed of that has gone against him.
Against her.
He has to challenge why you have come. That's surprising.
That the ground raised in the review with the rules is not applicable.
No, irrespective of the fact that you have made a application.
In that observation,
you have made an application under 47(1).
We have agitated that point. He already disposed.
You have made an application under order 47.
Order 47.
Review. So there is no point in going for the review. Reason being, simultaneously you have also complied the order of the tribunal by disposing the representation by a speaking order. So that order is complied. Now the opposite party was supposed to.
He has to
agree
challenge
with
that.
With that observation,
the writ petition has been filed by the petitioners, All India Institute of Medical Science, represented through its director and the deputy director of AIMS, challenging the order dated 10/10/2024, passed by the London Central Administrative Tribunal, Cuttack Bench, Cuttack in RA number 260/0019 of 2024. By annexure 6, and also to set aside the contempt application number 62 of 2024 under annexure 9. The London Council for the petitioners submitted that the opposite party, Doitari Swine, filed the filed the original application before the London Central Administrative Tribunal, Cuttack Bench, Cuttack, wherein the prayer was made, page number 31, internal page OG 12 brush. The London Central Administrative Tribunal by order dated 2/4/2024 dispose of the way and directed that directed the petitioners to reconsider the representation filed by the opposite party dated 2/1/2018 in the light of the judgment of the tribunal in OA number 239 of 2016, which had attained finality, and by passing the speaking orders, which is to be communicated within a period of 90 days from the date of receipt of the order. The Land Council for the petitioner submitted that challenging the aforesaid order passed by the London Central Administrative Tribunal on 2/4/2024. A review petition application was filed by the petitioners, which was numbered as review application number 19 of 2024. And the same was disposed uh, what is that RA number? What's this?
You were 19.
19 of
19,
2024. ଆଉ ଏଇଟା ଯୋଉ ଅର୍ଡରଟା ଯୋଉ ଦେଖଉଛନ୍ତି ତା ଦେହରେ ଗୋଟେ ଅଲଗା ନମ୍ବର
Then ସେଟା computerized number 260, then
260 oblique 19
19
oblique
outline.
of 2020.
which was review petition, which was your application, which was disposed of by order dated 10/10/2024, and the review application
along with them.
along with the MA was dismissed. When a pertinent question was put to the land council for the petitioners as to whether the representations which was directed to be disposed of by the Land and Central Administrative Tribunal in OA number 189 of 2018 by order dated 2/4/2024 has been disposed of or not. The answer was in affirmative, and the order of disposing of the order passed in disposing of the representation has also been annexed to under annexure 7, na?
Yes.
Annexure 7,
Page 180.
page, and the same indicates that it has gone against the opposite party. Since the representation has already been disposed of, in our humble view, there was no purpose in filing the review application before the Land and Central Administrative Tribunal, and also this writ petitions. If the opposite party is aggrieved with the disposal order of his representation petition, he is at liberty to take appropriate remedy, not the
See.
petitioners.
Yes.
See, all right, not the petitioners. Accordingly, we find no merits in the writ petition, which is dismissed. Yes.
No, Lordship, ma'am, that a contempt is filed, that's really In lieu of
It
that,
is submitted that the contempt application is still sub judice before the Land and Central Administrative Tribunal. It is open to the petitioners to bring it to the notice of this Land and Tribunal that the order has already been complied with, so that appropriate order can be passed by the Land and Central Administrative Tribunal in the contempt proceeding. Yes.
Obliged.
Item number 3, I am the Union of India. 6 week time to file counter.
No, Mr. Nandi is here.
Yes, sir.
No, how many times you have taken?
My lord,
You
taken but receipt hard copy, my lord.
what hard copy?
Hard copy from counter.
No, you made a statement. You means Mr. Padhi
Yes.
here and made a statement in November 2024 that he has received the parawise comment. Now and he will file the counter affidavit within 2 weeks. Now it is already 8 weeks past, and you are not filing the counter affidavit. The matter is getting adjourned from time to time.
My lord, last chance, my lord.
Yes,
My
Mr.
lord,
Padhi.
yes, my lord. We'll file the counter within a week, man.
No,
Within a-
you took time on 12/11/2020.
Yes.
Padhi.
Ah.
So, what do you want, that you personally pay some cost to the Bar Association welfare?
Last chance will be last chance.
All right. The Mr. Pari, Land Deputy Solicitor General, along with, what is your name?
Dilip Kumar, sir.
Dilip Shahu.
Dilip Sahu.
Dilip Shahu and Central Government Council seeks for 1 week more time to file the counter affidavit. Mr. Nandi, Land Council for the petitioner, objected for such adjournment for filing the counter affidavit on the ground that 2 weeks time has already been sought for on 12/11/2024. On this, after making a submission that the parawise comments have already been received, and Thereafter, the case has suffered another adjournment. Be that as it may, list this matter in the week commencing from 27th of January 2025. Counter affidavit be filed in the meantime. Copy be served on Mr. Nandi. Yes. Current counsel.
Who will
Item 6.
Item 6 note usual. On the last occasion, the Honorable Court had directed us to produce the certified copy of the order, of the entire order sheet of the miscase disposed of by the collector. But the certified copy of the same has already been applied for, my lord. I pray for 2 weeks time to produce the same. It has not been received.
This case number 9 of 2024.
No, no. Case number 9.
That order sheet you have already applied.
We have applied for it.
Certified copy. All right. The land and counsel for the petitioner submit that the petitioner has already applied for the certified copy of the entire order sheet of case number 9 of 2024 before the collector and district magistrate Kalahandi, but the same has not yet been received, and 2 weeks further time may be granted. Is this matter? Such answers. Yes.
Item 7.
My lord, in this case, the illegal and arbitrary action of the opposite party number 4 Miller, who is managing director of OPTCL Miller, has been challenged. For erection of electric transmission tower Miller,
Your representation is dated 4/11/2024, Annexure 7.
my lord,
You have not received any communication from the authority after you submitted the representation.
no communication.
All right, Annexure 7 is to be disposed of and order to be communicated. Yes, next.
My lord, till then status we maintain Miller.
Sorry, next.
My lord, till then
Item
status, they are going on.
Do not-
They are going on
Do not know
construction
what is
Miller.
there. Yes.
My lord, no they
Item
have
8.
acquired
All right.
land from.
All right. They will dispose of. We are fixing the time limit. Yes.
My lord, till disposal status we maintain.
Yes, next.
Otherwise, they are acquiring my land Miller.
Item number 8.
Yes, my lord. After passing the order by the Honorable Court, that was placed documents before the opposite party on dated 10th February 2023.
Your
But
authority
till
is
now,
diverting our attention.
My lord, in item number 7 by giving a personal hearing to us Miller.
Yes, item number 8. Please once again.
after passing the order by the London District Judge Khoda, I had placed the order with the concerned authority. I did Annex 2 P NHLI Land Acquisition Competent Authority from Land Acquisition Officer NH Khoda on dated 10th February 2023. I had Annex 2 minor.
No, what was the order passed by the London District Judge?
Minor. So that has been ordered passed in dated 22/2023 as per the order.
Come to the operative part of that order.
Minor. Minor, page 6 para 8 minor. Acquisition part of the operative party.
Page 6 para
Para
8.
8 is not there. Last paragraph is 6. Page 6.
Only page 6 para 8 minutes.
Para?
No, not that. Anyway, you read that one. Last but one.
Minor.
Since an area measuring.
On the application by the opposite party authority before the London Court of the District Judge Khoda Bhubaneswar, seeking orders on the
Mr. Counsel, are you holding this brief or some other brief?
No, my lord.
31146 of Yoda Darshan to?
My lord.
31146 raw. Annexure 1 huchi copy of the order passed by the London District Judge Khoda Bhubaneswar in NHLA case number 61 of 2014 bracket A, right? And the order is dated 22/2023. And the serial page number which you are referring to, There is no page 12.
17, running page 6, and the order in the order, the maximum paragraph is 6.
There are only 6 paragraphs. Where are we getting from 8, 9, 10? I do not know. That
12 paragraphs in my repetition.
repetition
No,
नहीं है.
no, no.
आपनकर order टा पढ़ुଛନ୍ତି.
No, my lord. I'm just reading over the petition, my lord.
No,
Page
no.
6.
We told you that you first place the order, operative
Right.
part of the
No,
order,
no, no.
impugned order.
No.
Mane, that order which was according to you, you are entitled to get the relief.
Order
Last-
dated
last-
20 February.
Page 17, my lord.
Place that.
Since an area measuring acres from 0.020 decimals is acquired by the National Highway Authority for the purpose of NH number 203 over the said plot, is to be constructed from the above narration and sketch map appended Exhibit A that the first purchaser of acres from 0.20 decimals of the suit land is entitled to 2 by 3 two-third share of the compensation amount, and the owner of reducible land measuring acres on 010 decimals is entitled to 1/3 share of the compensation amount. On the above observation, the application under subsection 4 of section 3H of the Act is disposed. The competent authority come land acquisition officer to verify as to past purchaser and disburse accordingly. This is the order.
What happened then?
Thereafter, I filed the certified copy along with your representation by Annex 2 before the opposite party.
Yes.
But till now, they have not receiving either any
All right, you obtain. Who is to obtain instruction? Who are the opposite party here? Competent authority,
land acquisition.
land acquisition officer. Whether the state would be obtain instruction or the council from the NHA. Acha. Then you are to serve a copy on that. Who is Mr. Amitabh Das used to appear? National Highway Authority, Amitabh Das, no?
That's Umesh Math.
So you serve a copy on
So I
Mr.
have
Das.
a copy, but I may kindly be call for a status report.
Let him come. This is a simple thing. Once he appears, then we can ask him that to take instruction. Why, whether they have acted upon or not acted, why they are sitting. Because it was submitted on 10/4/2023. So almost 2 years have passed. If it is not at least more than a year has a year and a half. Okay. The order, the petitioner has filed this writ petition for a direction to the NHI authority to take immediate steps for verification of the past purchaser and to disburse the compensation amount as per the order passed by the Land and District Judge Kurdar Bhubaneswar in NHLA case number 61 of 2014 bracket A. The Land Council submits that while disposing of the aforesaid case, the Land and District Judge Kurdar Bhubaneswar has been pleased to hold as follows. So you scenes and area achi internal page which is 6 running page 17 say to sesha porjanta inverted comma karibe. It is submitted that though the copy of the order passed by the Land and District Judge along with a representation has been submitted before the opposite party on 10/4/2023, but no communication has yet been received. Stop. Since Mr. Amitabh Das used to appear for the opposite party, bracket represents the NHAI, let a copy of the writ petition along with all the annexures be served on Mr. Das during course of this week in order to enable instruction regarding the status of the application submitted by the petitioner under Annexure 2, along with the copy of the order passed by the Land and District Judge for that Bhubaneswar under Annexure 1. Matter be listed in the week commencing from 3rd of February 2025, indicating the name of Mr. Amitabh Das in the first list. Yes.
Item 9.
My lord, I am challenging the order passed by the collector dashboard in land acquisition case by Annexure 6, my lord, case 29, my lord. The fact of case is that in order to develop the NH20 road, high road, the government made a notification to acquire the land, private land of the petitioners, my lord. And also,
May you come to straight to the order.
my lord, that is Annexure 6, my lord,
Read it, read it.
case 29.
Please pace it.
My lord. My lord, if you lordship can see the instant miscase, the second paragraph.
Yes.
The instant miscase has been instituted on the representation of the petitioners and as per kind orders of Honorable High Court of Orissa passed in WPC number 1329 of 2023. The contention of representation is that the NHAI authority has published a notification for acquiring the private land of the petitioners of village Bouranga for widening road of NH20 project, Kuakia to Koyangola, in Delhi newspaper as per section 3A of the NH Act. Accordingly, the petitioners filed their objection that if NH20 is passing through the village Boulanga, where more than 30 families are residing by constructing dwelling house, school, remission grounds, and Anganwadi center, etc., will be affected by the process of land acquisition. So they pray to take appropriate step in the interest of natural justice. Gone through the case record, along with written summations of the opposite parties, it is revealed from the report of LAO NH20 Jajpur that the Chief Engineer NH Orissa Bhubaneswar has been informed by letter number 47 dated 26/8/2022 and 132 of dated 16/4/2022 with a copy to the Principal Secretary Government Works Department Orissa Bhubaneswar for necessary action. In response to the above letter, the Chief Engineer NH Orissa Bhubaneswar has instructed the Chief Construction Engineer North NS Circle Bhubaneswar to make spot visit and submit a report along with his recommendation on the issue of Bouranga village by letter number 3931 dated 29/4/2022 and 8628 dated 6/9/2022. The land acquisition process of village Bouranga has been held up. Any information received from the National Highway Authority or Government of Orissa, necessary action will be taken up and same will be communicated to the petitioners. Accordingly, representation is disposed of. My lord. My lord, with lordship's permission, my lord.
How you are aggrieved by this?
My lord. Here, my lord, we filed an objection according to section 3C of National.
So a report was called for.
No, my lord. In last, my lord, they stated that accordingly representation is disposed of. That means my
Representation
my lord.
Dispose of who?
My
It is held up, correct? Process of acquisition has been held up.
held up. Yes. But my representation is disposed of. So when my objection is already
Mr.
disposed of.
Counsel, if the report comes against you,
My lord.
you can agitate it again. So ଆପଣଙ୍କର representation dispose of କରିବା ପାଇଁ ଆପଣ order ନେଇକିନି ଗଲେ ସେ consider କରିକିନି ଗୋଟେ report ମଗେଇଲେ ଏବଂ representation dispose of କଲେ ଆଉ କଣ କରିଥାନ୍ତେ?
My representation is relating to the objection.
And objection has been accepted and it has been held up.
My objection is.
You said that you will be affected by this acquisition and the authority said that yes, you will be affected so far and held up. The process of acquisition has been held up.
Process of held up ହେଇଗଲା ଆପଣଙ୍କ representation.
Now they are measuring our land.
Yes, that is the process.
That is the process because
with lordship's permission, according to section 3C, can I place my?
Yes, place it. What is it?
3C, my lord, National Highway Act.
You see, when you have come to this court for disposal of a representation,
No, my lord, my
the authority has to dispose of or it kept it pending.
My lord,
So if they have disposed of, if anything
You are
against
aggrieved with.
you have aggrieved, then you are to approach definitely. But the authority has already stopped that land acquisition process. They have held up it.
now they are acquiring our land, my lord,
Yeah,
without
acquiring our land.
considering.
It's a subsequent cause of action again.
No, my representation is regarding to the objection. If your lordship kindly see the section. my lord.
Whether your objection is justified or not, for that they have called for a report.
Report, my lord.
And
Yes.
for preparing the report, the measurement is necessary. And measurement is going on. Now you have come again.
No, according to section 3C, my lord.
Yes.
3A, my lord, 3A. Where the central government is satisfied that for the public,
Coda.
my lord,
3A is power to acquire land.
acquire the land.
Yes,
Therefore,
You are in 3C.
3C,
National Highways Act.
my lord.
Yeah. Yes.
Hearing objection, my lord.
Hmm.
Any person interested in the land may, within 21 days from the date of publication of the notification under subsection 1 of section 3A, object to use of land for the purpose or purposes mentioned in that subsection. Every objection under subsection 1 shall be made to the competent authority in writing and shall set out grounds thereof, and the competent authority shall give the objector an opportunity of being heard either in person or by legal practitioner, and may, after hearing all such objections and after making such further inquiry, if any, as the competent authority thinks necessary by order, either allow or disallow the objection. So here they should have called the parties and hear them.
Not mandatorily. It is there.
Last part of the order mechanism. After receipt of the report, the same will be communicated to the
Yes.
petitioner.
So it's a
Thereafter, they can
You have a
so
fresh
agree,
cause of action.
they would have some cause of action to approach.
right.
Either a reject on merit or rejection on
ଆପଣଙ୍କୁ କମ୍ୟୁନିକେସନ ହବ ନା ନାହିଁ ଏଇ ଯୋଉ ଅର୍ଡର ପଢିଲେ କମ୍ୟୁନିକେସନ ହେଲା ପରେ ଆପଣ ଯଦି ସେ ଅର୍ଡରରେ ଆଗ୍ରିଭ ହେବେ ତାହେଲେ ଆପଣ ଏଗେନ୍ ଆପ୍ରୋଚ କରିବେ ଆପଣଙ୍କୁ ଶୁଣାଯିବ ଆପଣଙ୍କୁ ତ ସେ ଟୋଟାଲ ବନ୍ଦ କରିଦେଇନାହାନ୍ତି ଫାଷ୍ଟ ଅଫ ଅଲ୍ ଆପଣଙ୍କର ଲ୍ୟାଣ୍ଡ ଆକ୍ୱିଜିସନ ପ୍ରୋସେସ ହାଜ ବିନ୍ ହେଲ୍ଡ ଅପ୍ ନମ୍ବର 1 number 2 he has sought for a report and after the report is received then it is to be communicated to you. If any necessary action is required to be taken, then it is to be communicated to you. Then you will get a chance to file that the report is incorrect if it goes against you. So why have you come again?
Premature. Your submission is also correct. According to the disposal of the representation, now they are going for the spot visit. They will make a measurement of it. Every aspect of the thing will be taken care of. In case
we have no objection that if they measure the land, but
All right,
now
take
that
the writ petition
with
has
their
been
observation.
all right. The writ petition has been filed by the petitioners. Was the order dated 21/9/2023 passed by the collector Jaspur in this case number 23 of 2023. It appears that earlier the petitioner approached this court in WPC number 1329 of 2023. For a direction to the authorities to consider the grievance petition filed by the petitioners along with their villagers. Division bench of this court had order dated 25/1/2023 dispose of the representation, dispose of the writ petition, and without expressing any opinion on the merits of the case, directed the authority that is opposite party number 7 to consider the representation filed by the petitioners and to pass appropriate order in accordance with law within a period of 3 months from the date of production of the certified copy of the order. The Land Council for the petitioner submitted that the copy of the order was produced before the concerned authority and the matter was taken up and the collector Jashpur opposite party number 7 has been pleased to held up the land acquisition process of delays of Boulango and considering the representation instructed the no, and and took into account that the instruction given by the chief engineer, National Highways Odisha Bhubaneswar, to the chief construction engineer, Northern NH Circle Bhubaneswar, to make a spot visit and to submit a report along with his recommendation on the issue of Boulanga delays. It has been further held that any information received from the NH authority or the government of Odisha, necessary action will be taken and the same will be communicated to the petitioners. Stop. It is the contention of the Land Council for the petitioner that that section 3C of the National Highways Act 1956 deals with hearing of objections, and it provides inter alia that when an objection is made to the competent authority in writing, the setting out the grounds thereof, the competent authority shall give the objector an opportunity of being heard either in person or by a legal practitioner, and may, after hearing all such objection and after making such further inquiry, if any, as the competent authority thinks necessary, by order either allow or disallow the objections. And any order passed by the competent authority under subsection 2 of section 3C of 1956 Act shall be final. The Land Council for the petitioner urged that when the report has been called for by the Chief Engineer, National Highways Odisha, from Chief Construction Engineer, Northern NH Circle Bhubaneswar, for spot visit, the representation of the petitioner should have kept pending and it should not have been disposed of. He further submits that the measurement is under progress and therefore the petitioner apprehends that the lands of the petitioners will be acquired by the government. Stop. We are of the view that the apprehension of the petitioner is totally misconceived because the spot visit, as per the order passed by the Chief Engineer, National Highways Odisha, the authority has made the spot visit, and since they are to submit a report along with the recommendation on the issue of Bolanga village, they are making the measurement. And if after the measurement is made and report is submitted and the comma, the same is to be communicated to the petitioner as per the impugned order. If the petitioner has any grievance after receiving the communication, he can again approach the concerned authority in accordance with law. Therefore, we are of the view that this writ petition is premature one and accordingly disposed of. Yes.
Item 10.
May I please allow? Now, this petitioner has earlier approved this summary report, the application number
3/4 double on 2020.
What is your prayer first? Tell us.
My prayer is the release of the compensation amount for acquisition of my land and extension of the
Okay,
benefit. under
you
the
earlier
current-
approached this court in WPC number 34115.
My,
So what order was passed?
the,
Representation disposed of.
yes, my lord.
Then what happened?
After this
Whether it
order,
was disposed of or not?
my lord, after this order is passed,
Yes.
the
You must have produced the order before the
I
authority.
have produced.
Then
but,
what order was passed?
In the no order has been passed, but in the meantime, the petitioners came to know from reliable source that the land acquisition officer has issued a letter to the Honorable Civil Judge Senior Division, Sundargarh, because the case was referred to the Honorable Civil Judge Senior Division, Sundargarh, in a reference case, number 24 of 2016. That was also disposed of in the meantime. And the Honorable Civil Judge Senior Division has directed to release the compensation amount in favor of the ousting, land ousting. But that has not yet been disbursed. So Lordship, kindly see Annex of 5.
Where is that order passed by the?
Page 26 now. This is the letter issued by the land acquisition officer to the Honorable Civil Judge Senior Division, Sundargarh. Page 26.
No, that is in 23. Where it states that reference case has also been disposed of. Reference case number has been given na 44 2016.
Page 27.
27, okay.
Page 27. Fourth para.
Fourth para means in the meantime.
Keeping in view.
Keeping in
view of order so passed by the Honorable Court, the Honorable Civil Judge Senior Division, Sundargarh had the order dated 4/2/2021 with observation to refund the land compensation amount of rupees 3,73,80,000 so deposited earlier in proper head of accounts of civil code to the land acquisition officer Hemgir for further disbursement amongst the land users of said Khata number 12 of village transfer. The copy of order of which so communicated by the member number so 11/2/21 addressed to the LAO Hemgir is enclosed herewith for favor of ready reference. Furthermore, and another case WPC number relating to same issue has been filed before the Honorable High Court, which disposed of on 16/12/2020. This is the writ application filed by the present petitioner. Next para. Also, the Xerox copy of the challan number 33 dated 24/6/2016 along with copy of Form E in token of deposit of rupees 3,73,80,000 are enclosed herewith for needful action. Page 28, my lord. I would therefore request your honor to kindly make arrangement to refund the aforesaid amount to the said bank account number of PNB Hemgir, IFCS code number at the earliest, as the time limit so granted by the Honorable High Court has already been elapsed. In the meantime, my lord, that civil deposit which was kept with the under Civil Judge Senior Division that has been lapsed. So the land acquisition officer under Annexure 6 has also requested the Honorable Civil Judge Senior Division Sundargarh for refund of lapsed deposit under head of account so civil deposit 104 civil court deposit for the financial year 2016-17 for the amount of rupees 3,73,80,000.
Then what happened?
This is still pending.
Your representation is pending.
And the petitioners have also made another representation, Annexure 7, before the Registered Civil Court Sundargarh.
19/9/2024.
My lord.
You have not received any communication.
No, my lord. This is still pending, my lord.
Annexure 7 is pending. Before sworn that is to be disposed of within time limit. Yes.
If the deposited amount in the way the materials sub judice in order to process the amount.
Let him
Place it as
say that what is going on because he is not communicating anything to the
LA. The civil court register cannot.
No, whatever it may be, it is to be
refunded. That has to be
actually
refunded.
you are to submit an RTI application that what happened to my representation. You have rushed to this court.
Yes.
So your status of representation, if once you file that RTI application, we would have easily known. But you have all the disposal of your. Yes, next.
Item 11.
Yes, Mr. Mahathi.
My short prayer, spare the land acquired for pipeline project. So the
Your representation is
yes,
there, annexure 15.
Annex 15, page 66.
Any other order passed earlier?
To approach the authority.
କାହିଁ ସେ order ଅଛି କି ଆପଣ ପାଖରେ copy ଅଛି ନା ନାହିଁ?
ମୁଁ
ନାହିଁ, ଆଚ୍ଛା, annexure 15 series to be disposed of. ହେଲା 22
by OP number collector
RDC
मैं RDC ଦେଇଛୁ collector କୁ ଦେଇଛୁ
କାହାକୁ ଯାଉଛନ୍ତି?
ଏଇଟା ହିଁ ଠିକ ଯାଉଥାଏ P3
ଆଚ୍ଛା, opposite party number 3
appropriate
ହେଲା OP
Right
number
authority RDC
alright,
opportunity of hearing
if necessary opportunity of hearing is to be provided. Opposite party number 3 huh? Yes, next.
Item 12.
Challenging the legal action of the opposite party in which
Representation is annexure 5.
annexure 4
4 na 5?
4, 3, 4, 5 conjugal 4
4 5 अच्छा 4 टा होची opposite party number 2 अच्छा 4 टा होची opposite party number 2 it is to be disposed of. Yes, next.
Item 13.
My application is annexure 3 now. Is still pending.
Annexure 3 pending, dispose of. Yes, next.
Item 14. Petition of seeks a direction to direct the tribunal to disposal of the case SA number 186 along the IU.
Madam, you are to produce the order sheet. Do not know that why it is. It was filed in 2023. Whether the parties have appeared or not. Whether they have.
For the bank,
Yeah.
waiting for final hearing. Pleadings are complete. Because in fact, I think few days ago it was listed before the DRT. Why? Where I fail to understand that. If some miscase has been filed afresh, I don't know. But as on what was filed previously, the pleadings are complete, madam.
No, we are actually. Once we started issuing such direction, there would be a.
It will open the
floodgate. So, in every case, they will rush here, and that is why we just wanted to see that order sheet copy. It is available with you. Please hand it over.
My lord, this is the order sheet passed by the DRT on 17/10/23. The London Tribunal.
Council, we are in 25. You are producing an order sheet of 23. Produce the updated order sheet. Let us see. This writ petition has been filed for a direction to the law and DRT for disposal of what is the case number?
SA number 186 of 2000.
Election the prior to total 9 SA number भी 9
Annexure 2
Say 186 of 23.
SA number 186 prior लिखिया वाली जो दरकार नहीं वाली हम क्या दी SA number टा देना था दे SA number 186 of 2023 let the land council for the petitioner obtain the order sheet of the aforesaid case. Please this matter keep रखियो phone.
Before any day before 29th, because the matter is fixed at 29th before the DRT.
Put up this matter on let that 29th date be over. 3rd of February 2025. Yes. The land and council for the
It has to be after.
The land and council for the party submit that the case is posted for hearing on 29th of January 2025. Put up this matter on 3rd February. The parties shall apprise the court about the status of the case. So also the status report.
Yes. Pray 4th, just one day, 3rd or some.
3rd, acha, 4th you want. All right, 4th February 25. Yes.
Item 15.
Yes, Mr. Dalai.
Item 16.
Petitioner is a trader for supply of veterinary medicines and vaccines. Let's see, kindly see page 31, my lord, for a moment, my lord. This is a registration of Udyam registration certificate, my lord, granted by the Ministry of Government of India, my lord, being a trader, my lord.
Then your lordship kindly see.
No, what is your prayer?
Prayer, my lord, I am challenging clause 3.1 and 5.2.8.
Tender matter.
My lord,
Why it
tender
has
notice.
come to us?
Well, I have mentioned before the Honorable Chief Justice, my lord. Chief Justice.
It has been assigned to us. Huh?
Okay.
All right. Take it easy. Yeah.
Yesterday I had mentioned before.
It's all right. Let us see. Just verify it.
There is
Top
the
of their
No? East?
as directed, place this matter tomorrow
Okay.
before division with number.
As directed. Is this matter
Well, see there.
tomorrow? Division bench.
Place
Before division bench. Free कौन रखा है जी? What is the DB3 manamo? Which is not name. DB3 कौन रखा है? All right. So what is your prayer in this writ petition?
lordship, in fact, I am challenging clause 3.1, my lord, of the tender notice.
Who is to appear for the opposite party?
Statement.
You have served a copy
No,
of the
I
writ
haven't.
petition. So come to your prayer. Let us see.
My lord. And page 28, ma'am. In the circumstances, therefore, felt that your lordship will be necessary pleased to issue a rule aside calling on the opposite party to show for the 5 clause 3.1 and 5.2.8 of the tender notice dated 9/12/2024 issued by the Director Animal Husbandry and Veterinary Services Odisha Mangalore Cuttack opposite party under assent shall not be passed with the opposite
Okay,
party.
please come to the tender notice. Let us see.
My lordship kindly see
Annexure.
Annexure 6, my lord. Annexure 6, page 84, my lord.
What is that two para? You are
3.1, my lord.
Fifth number paragraph.
Lordship kindly see page 89, my
Hmm.
89, my lord. The 3, my lord.
89.
89, my lord.
3.1 exchange upon.
My lord, 3.1, my lord. Is that lordship kindly see page 95. 95, my lord.
95.
My lord, 95 clause 6, my lord. My
95. 3.1 page 95. Yes.
my lordship kindly see 3.1 B details. Clause 6, my lord. Point 6, my lord. EMD, my lord. The bidder except OSME, MSC, stroke startup shall have to deposit EMD rupees 1 crore 20 lakhs along with the bid as per rule 212 Roman 1 of the OGFR 2023 and as per MSME Department Notification number 566 MSME dated 24/1/2024. Lordship kindly see page 142. That is the OGFR 1.212.1 million. 142 million. 142 is the OGFR minor. And lordship can say 150 minor.
150 is the clause 212.1, madam. That's got it. Bid security. To safeguard against the bidders withdrawing or altering its bid during the bid validity period in the case of advertised or to-bid tender inquiry. Bid security, also known as the earnest money, that the EMD, is to be obtained from the bidders except micro and small enterprises and startup. The bidders should be asked to furnish the bid security along with their bid. Amount of bid security should generally be between 2 to 5% of the estimated value of the goods to be procured. This is the important one. The amount bid security should be generally between 2 to 5% of the estimated value of the goods of the procured. Let's see, can you see for a moment page 84, that the bid document. Let's see, last part. 7 column, that is a tender value. Mention is tender value.
No, what happened that
In
tender?
fact, my lord, there is no estimated value.
No. What happened to that tender notice? That is dated 9/10,
9/10, my lord, today is the last date.
No, 9/12/2014.
Yes.
Or
24.
2024.
That is
You mentioned
14.
24.
9/12/24.
24.
So what happened?
My lord, in fact, as per the OGFR 212.1, my lord.
ଛାଡ଼ନ୍ତୁ ମୋ ସେଇ କଥା ଆପଣ ପକେଇଛନ୍ତି ନା ନାଇଁ?
ନାଇଁ sir, pocketing today is the last date.
ପକେଇନାହାନ୍ତି ଆଉ pକେଇବେ?
No, my lord. In fact, my lord,
If everyone is applying for
I
the
apply because this is contrary to the
whatever it may be, that's a different matter. Also apply it.
No, my lord. This is no, my lord. This is
Sorry.
No, my lord. This is the
petition.
Let's see, can you see
So the
contract 212.1, my lord.
They are not inclined to accept the stands dismissed. Yes, next.
My lord, this is 212, my lord.
All right.
Item 17.
Fifth, may please refer. In this matter, your lordship, the petitioner is seeking direction for the issuance of no due certificate as well as the original land records, your lordship, against which the petitioner has applied for loan, your lordship.
This is a matter to be single deal. Again, it is not a securitization.
ଆମେ କରିଥିଲୁ ଆଗରୁ ଇଏ କରିଥିଲୁ ନା ନାଇଁ ଏଇ ଟାଇପ ର ମ୍ୟାଟର ଆଗରୁ ଯାଇଥିଲା ଏଇ ଆଜି ତ କିଛି ଅର୍ଡର ହେଇନି ନା so we have to take instruction from the registry as you say that it's a single
because only secret matter will be in different matter, other matter bank matter will be single matter.
All right, the submission was made. You are appearing, Mr. Das, for whom?
For Canara Bank.
Acha, mention is made on behalf of Mr. Arupananda Das, the land counsel for the bank, that it is a single bench matter. Let the registry place a note. Let the registry verify the same and place the matter before the assigned bench.
Let us have a copy also.
And let a copy of the writ petition be served on the land counsel.
Yes, sir.
Yes, for the opposite party.
Okay.
Item 18.
My representation order annex 3 is pending before the OP3 manual.
P3.
P3 manual.
All right, dispose of.
Next item also same manual.
19.
Item 20.
Also same. Dispose of.
Here, not challenging the arbitrary determination of the valuation of the land and building matter. Is under annex 6.
Just
here. The arbitrary determination of the land, valuation of the land and building matter under annex 7. Here, the petitioner approached earlier approached this honorable court, and this honorable court has directed who while
Where is the earlier order passed by this court?
under annex 5, page 20, page 21, 23 minus.
Yeah.
Representation before the collector.
12/1/2023 is the order, and your representation was directed to be disposed of.
Disposal.
What order was
Here-
passed?
Here, without giving opportunity of hearing by the collector and land acquisition officer, my lord, they immediately go to the determination the matter.
No, whether there was any direction in the earlier division bench decision or order that the opportunity of hearing is to be provided to you while disposing of the representation. If not, then what is the order passed? On that
Well,
ground, it
that
cannot be
law.
set aside that
As a prudent order in accordance with law.
Representation
On production of certified copy.
so you produce the certified copy. There is no observation in that earlier order that personal hearing is to be afforded to you.
No, my lord, they have now.
Okay, now what is the after disposal of the representation? What order has been passed?
Nothing has been passed.
No, no. After you submitted the certified copy of the order, was there any order? Any order has been passed by the authority? Then
Where is the why have you come then? When
They
when
have
you
done-
submitted the representation? After the order of this court's order is dated 12/1/2023, and the authority was directed to consider the representation and dispose of within a specified time limit, but subject to condition that you are to produce the certified copy of the order. When you produce the certified copy of the order, what is the documentary proof? Then have you taken any averment in your petition that on such and such date I produce this certified copy of the order before the authority, and they have not taken any action? In fact, it would have been a subject matter of contempt petition if you would have given it to the authority, and they were supposed to dispose of it in 4 weeks.
That shows that there is
My lord,
no
in the
subsequent
meantime,
representation
they
along
have
with the orders.
determined the matter well and deposited in my
no,
bank
where
account.
from you got this?
And without considering any
No,
consequence.
there is a-
This is my, they have not given opportunity of hearing.
No.
And
Did you first file the certified copy before the authority?
already.
Where is that? There is no averment in your writ
After
petition.
date chart shows that after the order there is no such date
Nothing.
that
They have not done.
ଆପଣଙ୍କର ଡେଟ୍ ଚାର୍ଟ ତ ଦେଖଉଛି ଲାଷ୍ଟ ହଉଛି 23/11/2023 ଯୋଉଦିନ ସେ କୋଉଠି ଆପଣ ଲେଖିଛନ୍ତି ନେଇକିନି
12/1/23 order was disposition of disposed of 12/1.
ହଁ
Thereafter
12/23
jump over
order
3/11.
କୋଉଠି ନେଇ ପ୍ରଡ୍ୟୁସ କଲେ କୋଉ ଦିନ ପ୍ରଡ୍ୟୁସ ଲେଖି ନାହାନ୍ତି
ସେଇ
କିଛି?
ଜିନିଷଟା ନାହିଁ ତାର ମିଶି
Nothing.
12/1 jump over 3/11 then arbitrarily value that is.
ବାକି ଯଦି ଆପଣଙ୍କର ଭ୍ୟାଲୁଏସନ ଯଦି ଆପଣ କହୁଛନ୍ତି ଏଇଟା କମ ଭ୍ୟାଲୁଏସନ ହେଲା, you are entitled to more, then the
There is provision.
provision is there, and without taking recourse to the provision, why have you again approached this court by filing your writ petition that your representation has not been disposed of, or you have not given personal hearing when there is no such order in the earlier order, that personal opportunity, right? So
Demolition.
if you are dissatisfied with the quantum which has been stated, that valuation is this, you are agreed that this was at the lower side, then the recourse is available. That's what you are.
What happened, my lord? They did not cooperate because of I am filed the proposed values, proposed area. The lordship to go to page 62, serial number 16. Proposed area, they have quantified 9 decimal out of 15 decimal. Now, in my miscase file on 13/1/2025, 804, page
এটা ଆମର 2013 act ଅନୁଯାୟୀ ଯଦି ଜଣେ ତାର
my lord, they have also the RISS.
whether it is a national highway authority
or taken away.
Mr. Council, whether it is a national highway authority is to deal the, or the state has to deal the matter. It is the state.
Union of India is the party. National highway.
No, is it acquisition is by national highway?
National
You are
highway.
not aware. Then nothing.
57 national highway. But collector is 57.
Ladies and gentlemen, this petition has been filed by the petitioner Akhil Meher
How to bypass of NSA?
For a direction to the opposite parties, prayer देखिए लिखते हैं. It appears, Para, that the petitioner earlier approached this court in WPC number 36628 of 2022 with a prayer for a direction to the opposite party number 4. Who is opposite party number 4 in the earlier application? Earlier petition wrong. Opposite party number 4 kiye?
Collector.
Collector,
Both.
bracket like the opposite party numbers 1 and 2 to measure the land of the petitioner's plot in presence of the petitioner following the law of Land Acquisition Act. This court, by order dated 12/1/2023, without expressing any opinion on the merits of the case, since the petitioner had submitted representation before the said opposite party, dispose of the representation, directing the opposite party numbers 1 so say the opposite party to consider the representation and to pass appropriate order in accordance with law within a period of 4 weeks from the date of production of the certified copy of the order. Stop. When we put a pertinent question to the London Council for the petitioner as to whether the certified copy of the order was produced before the concerned authority in terms of the order of this court, though the answer was in affirmative, but it appears that no averment in that respect has been taken in the writ petition, and no documentary proof has also been produced before this court. Stop. The London Council for the petitioner submitted that now the petitioner has not been given an opportunity of hearing. Needless to say that in the earlier order passed by this court, there was no such specific direction that opportunity of personal hearing is to be afforded to the petitioner. Stop. The Land Council for the petitioner submitted that where is that valuation you are pointing out?
Extra 6 series.
Annexure 6 series. Page tag is
Page
26. Oh Lord.
building is
ଆପଣ ଯୋଉଟା ଦେଖଉଥିଲେ ବର୍ତ୍ତମାନ ଆମକୁ ଯୋଉ ଏତିକି amount fixation ହେଇଛି
That is
This is the market value on the
they have reframing
photo.
ଅବିକା
page
ଦେଖଉଥିଲେ
10 mine. Paragraph 10 page 8. 1 crore 8 lakhs 83,000 reframing.
No, ଆପଣ ଏଠୁ
That is
କୋଉଟା
at
ଦେଖେଇଲେ
page 60 to 60.
62 64
Proposed area.
amount ଦେଖଉନଥିଲା
Amount-
କୋଉଠି ଗୋଟେ ମାନେ
Amount.
amount decide ହେଇଛି ବୋଲି ଏତିକି
Inside
amount
page 8 paragraph 10.
Page 8.
8.
କାହାର ଆପଣ read petition ର?
Mine.
ସେଇଟାରେ ଆମକୁ
They determine and deposited in the bank.
the London Council for the petitioner has averred in paragraph number 10 like this one. So it is submitted by the London Council for the petitioner that the amount which has been determined, the valuation is at a lower side, and in case the petitioner would have been accorded opportunity of hearing, it would have brought the correct state of affairs before the authority, and the quantum would have been at a higher side. Stop. Be that as it may, since it is the case of the petitioner that the valuation which was made by the opposite party was at a lower side, recourse is available to the petitioner to file appropriate application before the authority for making reference.
Yes, sir.
For what is the provision?
For adjudication as arbitrator.
Reference provision is there.
But the collector as arbitrator is to decide, determine first.
That is exact.
This is NH.
This is an
NH 57.
one.
You see Annex 3?
Page 16.
No. He has asked for disposal of Annex 3.
No, this is the NH.
NH 57. This is NH 57.
State NH.
No, this is the
State NH is not NH, sir. This is State Highway, SH. This is NH, National Highway.
National Highway.
National Highway 57,
National-
Annex 3.
National Highways Act on Jeta deal.
To arbitrate upon the statement. That is what
That
you
is
are.
what we are telling. In accordance with law, in view of the provisions available under the National Highways Act 1956. ସେଟା କେବେ କେତେ provision ଗୁଡା ଯାଉଛି PG arbitration ଅଛି ପରା କୋଉ କଣ other 5 3G5 if the amount determined by the competent authority so and so
Yes.
is not acceptable to either of the party, the amount shall on the application of either of the parties be determined by the arbitrator to be appointed by the central government. So appropriate provision is available so and so the petitioner is to take recourse to such remedy. Accordingly, the writ petition is disposed of. Yes.
now they are going police building.
You will be getting this.
This now on 18 they are going to demolish.
No, you will get the compensation if you are dissatisfied. Compensation impact has been already determined. You are to receive it. If you are dissatisfied and you claim for higher compensation, provision is available under the National Highways Act
They
1956.
did not measure my building man. This is the
Yes, next.
Item 21.
Milords, in this matter, I am through VC Lordship. Milord, the matter is listed for hearing on my IA for a regular bail. Lordship, I am in jail since 23/8/2011. I am seeking bail on 3 grounds. That I have suffered 13 years, 4 months of custody. Second, there is no likelihood of appeal to be heard in the near future. Third, there are certain recent guidelines of the Honorable Supreme Court for the consideration of suspension of sentence. And fourth, on the merit lordships. I have my associate is there with the custody certificate, lordship. Lordship, it's a very good case for exercising the merit because in one line, the 5 persons were prosecuted for 396 and 3 has been acquitted on the merits. Only 2 persons has been convicted. And there the sine qua non
Was earlier rejected or what?
No, my lordship. My regular bill has not been heard yet. The 3 IA was heard first. 1 IA was heard for the marriage of sister.
It was verified.
The application is
My lord.
listed before us since one of us was party to a bench which rejected earlier similar petition. Administrative order, right? In case of
Yes.
This was an IA lords, and I had mentioned both the IA before this honorable court. Lordship had allowed my IA.
Just wait.
Sorry, lordship. I'm sorry.
not fixed. Now it has come, which application is now?
Lordship, IA number 139/2014.
The earlier application which is pending.
It was filed along with the appeal, Lordships. And my no regular bail has been heard yet.
All right. What is, according to you, how
Lordship.
many years you are in custody?
Lordship, 13 year, 4 month, 23 days.
So where is this?
And
let us see the custody certificate.
yes, Lordships. If Lordships see the page number 2 of the custody certificate,
What this 4893, huh?
yes, Lordship, if my Lord see the page number 2 of the custody certificate, entry number 1 shows the date of arrest, 23/8/2011. Lordship, from that very date I am in jail. I never.
Have patience. We are perusing something and you are giving running commentary. 4893, if it is divided by 365, how many years it is? State Council. 13 years. 13 years.
28 days.
That's all right. Now he is pressing that 2014 application which has been filed for bail, that he is pressing the application on merit, because on merit the bail application of the petition was never considered. That is how he is pressing. So you have got the paper book. It must have been prepared, na? Paper book
Yes,
is
Lord.
with you.
Paper book is prepared.
Prepared. So,
My Lord, may I argue?
just a minute. Let us see that. Manoj Pradhan is PW.
Manoj Pradhan is IO.
Manoj Pradhan is the informant.
Complainant. Yes, Lordship, he is a
PW
18.
18, 18.
Yes, Lordships.
What is the date of arrest?
Lordship, it's 23/8/2011.
23
8 2011.
2011.
Yes,
Is there any
Lordships.
test identification parade has been conducted
Yes, Lordships. Yes, Lordships.
with that magistrate examined?
Yes, Lordship. No, Lordship. The magistrate was not examined as a witness in the court.
Magistrate has not been examined.
In the court as a witness.
That TI parade report has been proved.
Yes, Lordship. The document was
What is
proved.
that TI parade
Yes.
report?
Yes, Lordship. The complainant has identified me. My role.
Mr. Counsel, you have been identified in court. We are asking you that whether any test identification.
TIP also. TIP also I was identified. Lordship, in the page number 185. My role has been assigned.
Yes, in paragraph number 4 also he has
4. Yes, Lordships. But he has stated, Lordships, in the para number, in the top of 184, Lordships, the role that these two accused persons, the witness identified S.K. Noor and S.K. Yaqub as standing inside the court dock in the presence of their lawyer, are the persons who tied my leg with the rope and threw me down the hill. Only this role has been assigned to me. And 5 persons were prosecuted. There is no allegation that I did any physical injury, lordships.
No, it's all.
And when
Even if Mr. Manohar,
lordships,
from the evidence of this PW 18, the
Lordship.
information driver of the said vehicle, Bolero, it appears
Yes,
that
ma'am.
you were in that vehicle.
Yes,
and,
lordship.
Some overtact has been attributed against you. You are right that in paragraph number 2, he has stated that one of the 6 persons
Yes, lordship.
dealt blows on the deceased on the head, and
My lord.
and he has not specifically stated that
Yes, my lord.
person is this appellant.
Yes, my lord. That is my submission.
That has been attributed that what you have done.
Yes, lordship. Yes, my lord. The main submission, lordship, just 2 lines. The sign for the offense of 395 is that there must be 5 persons. There are a series of judgments of Honorable Supreme Court which holds that if two
ingredients, yes,
if 3 persons has been acquitted, lordship,
so he has stated how many persons are there in that vehicle.
But 3 persons has been acquitted on merits. So 2 persons cannot be convicted on 396.
No, what is the judgment as it appears? 5 persons face trial.
Yes, lordships.
And
3 has been lordship. It's in the page number 59.
50 no.
9. Paper book.
Benefit of doubt or clear acquittal?
Clear acquittal on the merits, lordship, of the 3 co-accused.
Okay, that is the reason why you are acquitted also of the charge under 396.
Yes, lordship, on each and every charge.
No. You are hereby acquitted on so on. Prosecution has not been able to establish the charge under 506 against accused accused, therefore not held guilty. Prosecution has successfully established charge 396 against so and so.
And one more aspect needs to
let us see the charge.
be seen, lordships. One more last aspect.
Charge.
There are.
Wait.
My lord.
So, Mr. Naik, the point which he is raising, that if it is a charge under section 396, there should be material available on record that at least 5 or more person participated in that crime. The charge is, as it reads, that you along with 5 to 6 others. So all those 5 persons were faced trial and the charge was that you along with the 5 persons. So when the 5 persons face trial and the order of judgment of 3 of them have been acquitted. Is there any finding in the impugned judgment that even those 3 have been acquitted, there are other persons who participated with these 2 persons? Because the number has to come to at least 5. Otherwise, it cannot be a conviction under 396. Docket with murder. So for that, it requires 5 persons. That is one of the submission. So
lordship, one more point, lordship. If we see the Bear Act, in 396, there are 3 types of punishment. First punishment is up to 10, second is life, and third is death. There was no good reason for the learned trial court to impose the higher punishment. Since I don't have any antecedents, the punishment policy says that if there is no antecedent and the role assigned is not so high, then the minimum punishment should be awarded. So minimum punishment should have been 10 years. So I have already suffered that punishment, Lords. Even if the conviction is sustained, I have already suffered that punishment. So in light of all these things which are in my favor, my bail should be uh, positively hard, Lordships. That's my prayer. And if we see there no the witness PW18 has specifically said that I had not hit that person deceased. And who is that person? He was never arrested. He was never brought to trial court. He never faced trial. Who is that person? And one more surprising thing, there is no disclosure statement, Lordships.
Or the land counsel for the petitioner, land counsel for the state. The land counsel for the petitioner submits that the petitioner is in judicial custody since 23/8/2011, and he has produced the custody certificate which issued by the Superintendent Circle Jail Koraput dated 15/1/2025, which indicates that the petitioner has remained in custody for more than 13 years. Custody certificate is taken on record. The Land Counsel for the petitioner submits that 5 persons face trial, including the petitioner, before the Land Trial Court for inter alia for offense under Section 396, out of which 3 have been acquitted. And there is no finding that these 2 petitioners, along with others, committed the crime so as to satisfy the ingredients of the offense under Section 396. He further submits that PW 18 Manoj Pradhan is an eyewitness to the occurrence. He is also the informant in the case, and he has lodged the FIR against unknown persons. And while deposing in court, he submitted, he stated that so far as deceased Sudhir Parida is concerned, one of the 6 persons dealt blows on the head of the deceased by means of cutting weapon called as meat chopper, as a result of which the deceased sustained bleeding injury. He further submits that then 2 of those 6 persons pressed down the head of the deceased in between the 2 front seats of the Bolero vehicles, and they also closed the window gate so as to prevent the alarm of the deceased to go outside. The Land Counsel for the petitioner submits that the informant bracket PW18 has not made a specific statement while deposing in court that the present petitioner is the person who assaulted by means of meat chopper on the head of the deceased. And the conviction of the petitioner, there are good chances of success in the appeal, and even though paper book has already been prepared, since there is no chance of early hearing and the petitioner is a local man, the bail application may be favorably considered. Stop. London Council for the state, on the other hand, opposed the prayer for bail and uh, placed the evidence of PW 18 and submitted that the petitioner was not only identified in the test identification parent, but also in court by PW 18. And some overtact has been attributed against the petitioner by PW 18, which should indicate that the petitioner was present at the time of occurrence in the Bolero vehicle. Considering the submission made by the London Council for the respective parties, nature of evidence adduced by PW 18, period of detention of the petitioner in judicial custody, absence of any chance of early hearing, we are inclined to release the petitioner on bail allowed.
I'm deeply obliged, Lordship. Lordship, one more submission. I have filed my VNAMA on the basis of prisoner's petition. So the name of other lawyers may be removed.
Grand Council submits that he has filed the VNAMA on the basis of the prisoner's petition. The names of the other counsel, except Mr. Sam Manohar and his associate, shall not be reflected in the cause list henceforth. Yes.
I'm obliged, Lordship. I'm so grateful.
Item 22.
Please, your Lordship, here I appear for the appellant number 2, who is in custody since 6/6/2017.
6/6/2017. Have you got the custody certificate with you?
There is no custody certificate. He was taken into custody on 6/6.
No, because Mr. Panda, during that COVID period, some persons were released. So that is why we are
during the COVID period, the appellant 2 was also released on bail.
So you obtain that custody certificate. The Mr. Devasis Panda, Land Council for the appellant submits.
Appellant number 2.
Appellant number 2 submits that the appellant number 2 is in judicial custody, was taken into judicial custody, not allocated Babuli Sahu on Kebe 16/6/2017.
I'm sorry, 6/6/2017.
6/6/2017.
Yes.
2017. Let the Land Council for the state obtain the custody certificate. Which jail is now?
With that internal jail.
Matter to be listed in the week commencing from 27th January 2025.
It is reflected also in the order sheet.
What is
that? Custody period. There is no custody certificate.
No, that is to be off. Yes, next.
Then for both appellants, he should obtain Miller's, otherwise it will be.
You have filed for one, Mr.
I have filed for one.
Did you?
But then since this is an appeal, there are two appellants.
All right, okay. We'll see that. Yes, next.
Item 23.
May I agree?
Yeah.
Conviction Conclusion. The appellant convicted under section 302 of IPC manner, along with offense on section 3 of Explosive Substance Act and 9B of Explosive Act, my lord. By virtue of the order dated 18/12/2024, my lord directed London State Council to bring a report with regard to the criminal assistant and custody certificate.
And we have received the custody certificate. Kete varsh ହେଇଛି?
Inside custody 14/7/2017. 14/7/2017.
Just please wait. অবশ্য 6 মাস হয়েছি এটা আজন ডিসেম্বর ওকে নাও your bail application was never rejected
For the first time.
so what is the prosecution case?
Yes, of the prosecution case, my lord, is alleged that on the alleged date, that is on 9/7/2017, my lord.
Date of occurrence is 9/7/2017. Okay.
It is alleged that present appellant along with others threw bombs towards the deceased, my lord.
What is the name of the deceased?
Abhimanyu Das, my lord.
Abhimanyu Das.
Yes, ma'am.
How many persons faced trial?
There one person faced trial, my lord.
You said that you along with so many.
Yes, right, my lord. During course of evidence, my lord, all the witnesses have been implicated, present petitioner along with others, my lord. And present accordingly, investigating officer has exonerated him at the submission of charge sheet.
No, you charge sheet was submitted only against you.
Against one person.
Or let us come to the FIR. Let us see. Trial court record.
Informative PW4, my lord.
No, FIR person. Initial story कौन थिला? ମାନେ ଆସିଲେ ତାପରେ କଣ ହେଲା ଦଳବଦ୍ଧ ହୋଇକିନା ଆସିଲେ ସେମାନଙ୍କ ମଧ୍ୟରୁ ଆସାମୀ ସୁଆଂଶୁ ହାତରେ ଗନ୍ ଧରିଛନ୍ତି
ଆସାମୀ ପୂର୍ଣ୍ଣଚନ୍ଦ୍ର ସାହୁ appellant, my lord. C.DASH. Thereafter Anandiji Nandakishore Hon'Ble.
ନାଇଁ ତତ୍କ୍ଷଣାତ୍ ଆସାମୀ ପୂର୍ଣ୍ଣଚନ୍ଦ୍ର ସାହୁ ମଣ୍ଟୁ ଅଭିମନ୍ୟୁ ଦାସର ମାନେ ଅଭିମନ୍ୟୁ ଦାସର ଡିସି ଛାତିକୁ ଲକ୍ଷ୍ୟ କରି ଏ ବମ୍ ଫୋପାଡ଼ିଲା ସଙ୍ଗେ ସଙ୍ଗେ ଅନ୍ୟ ଆସାମୀ କାଶୀନାଥ ସୁଆଂଶୁ ଉଭୟ ଦୁଇଟି ବମ୍ ମଣ୍ଟୁକୁ ଜୀବନରେ ମାରିଦେବା ଉଦ୍ଦେଶ୍ୟରେ ଫୋପାଡ଼ିଲେ ଅନ୍ୟ ଆସାମୀ ସୁଆଂଶୁଙ୍କୁ ବଡ ପାଟିରୁ ମାରି କାମ ସଫା କରିଦିଅ ଆଚ୍ଛା ଏଇ ଟାଇପର ଇନକ୍ଲୁଡ କଲା ସମସ୍ତଙ୍କୁ ଆପଣ କିନ୍ତୁ କହିଛି ଯେ ଛାତିକୁ ପକେଇଲେ ତାପରେ ଅବଶ୍ୟ ଅନ୍ୟ ଦି ଜଣ ପକେଇଲେ ବୋଲି କହିଛି now that man informant has been examined as PW.
He has been examined as PW4, my lord.
PW4 is the Premolata Das.
Yes, ma'am.
Apart from her,
yes, ma'am.
Any other witness?
So far that other witnesses concerned, my lord, there is a eyewitness is the PW14, my lord.
No, PW4 tapra eyewitness?
No, PW4, it is alleged that after the incident, the PW4 rushed to the spot and the deceased made a disclosure before the PW4 with regard to the implication of a present appellant along with others.
Dying declaration ki goi?
Dying declaration, oral dying declaration.
Who ki goi?
That has been stated by the PW4, my lord, Premolata Das, and other witnesses are PW1, PW3, PW6 and PW8, my lord.
So one, just a minute, Mr. Das, eyewitness gote ebong dying declaration gote.
Yes, ma'am.
So eyewitness ro evidence kiye deyichanti?
So far that my subject to verification by the London State Council, PW14 is the eyewitness, my lord.
PW14?
Yes, my lord.
Okay, then who are the witnesses to the dying declaration?
Yes, my lord. PW14 has not supported the prosecution case, my lord.
Eyewitness support karni?
PW14, my lord. So far the oral dying declaration is concerned, that is PW1, PW3, PW4 informant, PW6 and PW8, my lord.
PW6, PW8,
man.
Acha.
Trial court in inner page number 42, my lord, and
started a discussion with regard to the nature of evidence, my lord,
Hmm.
and also concluded the same in the page number 45, my lord. I'm placing that relevant persons. On their arrival, deceased himself disclosed about the incident before them under such
Two paragraph. What's the page?
page number 45, lordship, towards the end of
Paper book to the paper book. Put through 45.
judgment.
Judgment to put 45.
Inner page 45, we have annexed maybe page mapping. Judgment type pen is 27.
Wait. Paper ऐसे appeal memo भरते. Appeal memo जो judgment है 45.
Oral dying declaration is also before
On
PW1.
their arrival, deceased himself disclosed about the incident before them.
dying declaration. 14 टा होची आई विटनेस जे की सपोर्ट करना. तो dying declaration ने कौन आइला कौन सा पहले?
Present appellant along with others participating in the alleged crime.
नहीं bomb कथा पहले.
Bomb aspect is there, my lord. What that in PW4 has stated in the FIR, my lord. He has corroborated the same while giving evidence, my lord, and placing that evidence of PW4 for my lord's appreciation. I am the informant in this case. Deceased is my son. I know the accused which is standing in the dock. The occurrence took place on 9/7/2017 at about 10:30 to 11 p.m. During said relevant period, I was sleeping in my house.
Just take pause for a moment. We have gone through the FIR. In the FIR, we don't find. We find that as if she has deposed, as if she was an eyewitness to the occurrence.
Right, ma'am.
She has not stated that the source of knowledge was from dying declaration. Is it there in the FIR that any dying declaration was made?
That
Rather, he has stated as if he was.
No, that from narration of FIR, it appears that he is an eyewitness to the occurrence.
Yes, that.
During course of evidence, my lord.
She has stated that she was a post-occurrence witness, but came to know it from the deceased. Right.
Yeah.
So dying declaration विषय से कहला. Dying declaration है जो कहिला. Let us come to that evidence. PW4.
4, my lord.
कौन कहला?
With my lord's permission, I am placing. On being asked, he narrated before me that accused Purnachandra Sahu in presence of above said persons threw a bomb on him, as a result of which sustained bleeding injury to his chest. Said Nandakishore Samal, Abhilasha Samal, Kasinath Dhala, Rakesh Khilar, Rabindra Khilar, Divya Ranjan Bevra, instigating the said Purnachandra Sahu to kill him in the light as instructed by MLA, and MLA who will bear all cost of expenditure of the crime.
Okay, so PW4 has named you in the dying declaration.
Yes,
what about PW1?
PW1 placing.
There is a part of
Yes,
dying declaration part.
On being asked, this is told that accused threw bomb along with Rabindra Khilar, Abhinash Samal, Divya Ranjan Bevra, Nandakishore Samal, Kasinath Dhala, Naluha Khilar were persons threatening to end him. I, along with others, shifted the deceased to medical doctor. Doctor declared him dead.
6 also same thing.
Same line.
What about so and so? Right.
Rule 5 and 7 also. They are the eyewitness.
Trial court has also.
Okay, so that evidence, dying declaration evidence, is somehow rather consistent that it is you who has thrown bomb at the deceased.
Yes,
now, who is the doctor?
Doctor is my lord. Doctor who conducted postmortem.
Yes, Dr. PM.
PW21.
PW21.
Dr. Vidyadhar Pradhan.
Has he stated that these injuries which he had seen as per the PM report, it is possible by bomb throw?
Actually, blast injury is the cause of death.
Cody.
Opinion.
Cause of death is so and so, cause of
cardiogenic hypertension due to blasting. Admittedly, informant has implicated present appellant along with the Subsequently, informant has implicated the present appellant along with others.
along with two persons
Two
who have
persons,
thrown
and
bomb ମାନେ ତିନିଟା ଲୋକ ବମ୍ ପକେଇଲେ ବୋଲି କହୁଛନ୍ତି।
Subsequently, she changed her persons.
Change
And but
ମାନେ
in some or other
ଜଣଙ୍କ ନାଁ
persons
କହିଲେ
are there.
ଅନ୍ୟମାନେ ଥିଲେ ବୋଲି କହୁଛି।
She level.
And Schedule 5 also stated the he has seen that and he has shown the bomb. Schedule
ନାଇଁ
5.
ନାଇଁ ସମସ୍ତେ ଟ୍ରାଏଲରେ ସମସ୍ତେ କହୁଛନ୍ତି ଇଏ ବମ୍ ପକେଇଥିଲା ବୋଲି। କିନ୍ତୁ ଏଇ ଯୋଉ ଏଫଆଇଆର ସେ କହୁଛନ୍ତି ତାଙ୍କ ଇନିସିଆଲ ଷ୍ଟୋରିଟା ହଉଛି ପିଟିସନର ବମ୍ ପକେଇଲା ତାପରେ ଆଉ ଦି ଜଣ ମଧ୍ୟ ବମ୍ ପକେଇଲେ ସେ ପଢିଲେନି କି ଆଜ୍ଞା ଏଫଆଇଆର ଟା ପୂର୍ଣ୍ଣଚନ୍ଦ୍ର ସାହୁ ମଣ୍ଟୁର ଛାତିକୁ ଲକ୍ଷ୍ୟ କରି ବମ୍ ପକେଇଲେ ସଙ୍ଗେ ସଙ୍ଗେ ଆସାମୀ କାଶୀନାଥ ଧଳ ଏବଂ ଆଉ ଗୋଟେ କଣ ନାଁ ହଉଛି ରାକେଶ ଥିଲା ଉଭୟ ଦୁଇଟି ବମ୍ ମଣ୍ଟୁକୁ ଜୀବନରୁ ମାରିଦେବା ଉଦ୍ଦେଶ୍ୟରେ ଫୋପାଡ଼ିଲେ ତେଣୁ ତିନି ଜଣ ବମ୍ ପକେଇଛନ୍ତି ବୋଲି ସେ ଥିଲା ଇନିସିଆଲ ଷ୍ଟୋରି ସେ କହୁଛନ୍ତି ଟ୍ରାଏଲ କୋର୍ଟରେ ଇଏ ତ ହୋଷ୍ଟାଇଲ ହେଇଗଲା ଆଇ ୱିଟନେସ୍ ଯୋଉମାନେ ଡାଇଂ ଡିକ୍ଲାରେସନ କହିଲେ ସେମାନେ କେବଳ ଜଣକୁ କନଫାଇନ କଲେ ହି ଇଜ ଦ୍ୟାଟ ଆପେଲାଣ୍ଟ
That apartment deceased is history sheeter, my lord. That aspect has also been admitted
what
by
is what about your criminal antecedent
because that is not available.
That accident is not
ଏଇଟା ବମ୍ ଫମ୍ କେସ୍ ଗୁଡାକ ଆଣିବେ ନା ଆଉ କେମିତି ତ ଏଇ ଯୋଉ ଖାଲି ସିଏଟା ନେଇ ଆସିଛନ୍ତି
custody certificate.
କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଆଣିଛନ୍ତି ସେଟା ଆଣିନା ଏଟା ଆଣୁ ତ ବମ୍ କେସ୍ ମାନେ ନିଶ୍ଚୟ ଦେଖିବାର କଥା ଦେଖନ୍ତୁ ଦି ଲର୍ନିଂ କାଉନ୍ସିଲ ଫର ଦି ଷ୍ଟେଟ ଏଟା ଅର୍ଡର ଶିଟ୍ କରିବ submits that as for the as per the order dated 18/12/2024 though he has received the custody certificate of the petitioner but he is yet to receive the instruction regarding the criminal antecedent if any against the petitioner and some time may be granted in that respect he files the custody certificate which is taken on record put up this matter in the week commencing from 27th January 2025 the Land Council for the state shall produce the instruction relating to the criminal antecedent. Yes, no, next.
Item 25.
Last directed to produce the custody certificate and also notice of issue.
Just a minute. Two order है 18 15 that one also
Passable item number 15.
okay so which one extension of time that one
Item 26.
We do not have to file 2019 before the case, my lord. The
No.
petitioner has also expired.
Who has filed this application for extension of time? Oh, petitioner has expired. Listen, IA number so and so, there is an application for extension of time. It is stated at the bar that the petitioner is dead. In view of such submission, the IA is disposed of. Next.
Item 27.
Sir, I am kindly permitted to place the matter.
Yes.
And due to the death of associate of sudden death of associate who is dealt with the matter, due to massive heart attack, the file was kept with him. So it was not came to my Mr. Rauter's knowledge.
You know, what do you want now?
Restoration of it.
Madam,
File an
you have
application
filed
for
the
restoration
CMAPL,
after long period.
but the stamp reporter has pointed out that there is a delay of 364 days.
Yes, ma'am. Yes, ma'am. After 1 year,
So,
I filed this.
it's all right. So for that, notice has to be issued. For
Yes.
condoning the delay in filing the CMAPL, notice has to be issued. That has not been done. Right?
Yes, ma'am.
But on the last occasion, you time that you are to file the copy of the dismissal order, which is impugned in this case.
I already filed.
You have filed.
Yes. 10/1/25. I have filed the
Okay,
certified copy.
just a minute. Let us see. 10/1/2025 already. Look on the learning counsel for the petitioner submitted that he has complied the wanting which was shown by the stamp reporter relating to the filing of copy of the dismissal order which has been impugned in the CMAPL on 10/1/2025 with a memo. Same is available on top. IA number 321 of 2023 is an application for condonation of delay in filing the CMAPL. The stamp reporter has shown 364 days delay in filing the CMAPL. Issue notice to the opposite parties. So there are, as it appears, there are 4 opposite parties.
Yes.
So whether the Mr.
Union of India, ma'am.
So all these opposite parties, you are to appear. Just see the cost title. Cost title does it.
Yes,
So okay. The learning counsel, Mr. Padhi, along with Swan, submits that he will they will appear for all the opposite parties. Let copy of the interim application be served on the learning counsel for the opposite party. अच्छी जो interim application उड़ा दे दो ना ना नहीं
Not today.
by tomorrow मैं by tomorrow.
Okay.
Matter be listed in the week commencing from 27th. यदि किसी objection करेगा तो objection if any to the IA be filed in the meantime.
Along with the CMPL copy because
along with IA along with CMAPL copy and IA to be supplied to the learning counsel for the opposite parties.
Obliged, ma'am.
Just